All right, good morning, everyone. The meeting is called to order. Mr. Trobman. Has anyone signed up for public comment?
Good morning, Commissioners. Les Trobman, General Counsel. We do have two individuals who have registered for public comment this morning. The first one is Hasib Abdullah. Mr. Abdullah, if you could go ahead and introduce your name for the record and then proceed with your comments.
Thank you. Can you guys all hear me?
Yes, sir.
Oh, great. Chair, Commissioners, my name is Hasib Abdullah, and I live here in Central Texas. I just want to thank staff for making this possible at TWC. I'm not going to take too much time, and I'm not going to say anything new that you don't already know about. I just wanted to state my opinion about, as a citizen of Texas, and give my opinion about obviously what's happening, I guess, during the COVID times and unemployment benefit fraud, that the numbers are truly unbelievable during fraud. And even though the amount given out was much larger, and the amount, the fraud that was detected during COVID was extremely large. So your agency has done a great job in that, in preventing and detecting it ahead of time. Whether the $900 million is a true number or not, or if it's much higher, it's much lower, somewhat higher, somewhat lower, that's still a very big number as well in terms of our taxpayer in dollars, Texas and federal, I guess, matching, that has been defrauded by people who took advantage of all of us during uncertain times. And while I think canceling debit cards given out is a good start, I think that's one thing that's happening right now. I think that Texas, I'm sure in some respects it may have already been doing this, but should definitely work with the 49 other states who've had some issues, sometimes much worse than Texas, in trying to find solutions to canceling the fraud before it's used, or it's getting the money back in some way or some fashion. Obviously, with if the numbers are accurate, there's tens of billions of dollars across across 50 states. And so there's a huge financial incentive by everyone. Probably I've never seen, a high, these numbers are truly, I think, there's never been a larger financial incentive to try to get that money back. And obviously, secondarily, if possible, punish the perpetrators. Even though that would be a little bit tough, because even though some experts are saying some of this might have been done by international actors who deal in fraud and other criminal enterprises. But I would also say I think the time is the essence. The longer this isn't directly headed on, the less chance any of that money will be getting back or canceled in some fashion. So I definitely think working with other 49 states, see if they're what they're doing, who's successful, who's not, and moving as quickly as possible in this would be something that we all Texas citizens would really appreciate, and all American citizens in general, for the unbelievable amount that's been detected. But not to take away from what you guys did do, give out much larger amounts, and also detected and prevented a huge, large amounts of fraud that would have gone, that in some cases, maybe some other states did not have the resources and the talent that your agency has. So great job on that. The next thing and the last thing I want to talk about briefly is specifically federal disability benefits. Again, nothing new. You've heard this all before, I'm sure. But like for example, supplemental security income and others are typically federal only. So the benefits, unlike the state does not have a direct financial incentive, I would say, any state, to help its fellow citizens, including Texas, get back to work. At least not, in terms of who's paying and ponying up the money, like it does with, for example, the current unemployment scheme, where obviously there's a federal enhancement, and then there's obviously there's always a state component into it. So getting back to work, or even in some cases even canceling the federal enhancement that's happening in a couple short weeks, is one example of that incentive. No doubt that TWC has a great back to work training programs for people who have disability. But what I think, and obviously those are helpful and stuff, but I think in some rare cases, federal disability benefits can lead to a cycle of dependence and poverty in some aspects. And one possible, seemingly against our own interests, a solution would be, I think, to ask federal legislatures, our federal legislatures, our senators and or dozens of Congress men and women to help pass bipartisan legislation to where states are also on the financial hook of what is now federal disability benefits. This would incentivize all states, including Texas, like they do not currently have, on an ongoing basis, to look for solutions to get people back to work on an ongoing basis. That's the thing. Like, it's one thing to have a grant program or a program. If you have a skin in the game, obviously, it's just like these federal unemployment benefits. I think you have an incentive that not just Texas, but the 49 other states would have. And I think it would help society in a tremendous fashion. Thank you this morning for letting me talk. Thank you for all your time, Chair, Commissioners, and thank you for your service.
Thank you. Our next commenter is Clint Williamson. If you could just go ahead and introduce yourself for the record and proceed with your comments. Mr. Williamson, are you there? You may be on mute, Mr. Williamson. We may be having some technical difficulties. So with that, those are our commenters this morning.
Thank you. Good morning, Ms. Miller.
Good morning, sir.
We have no cases to reconsider under agenda item 3, is that correct?
Correct, no cases.
We'll now consider tax liability cases under agenda item 4. We have 2 tax cases on docket 24.
Yes, sir, there are 2 cases. The first is case number 20-096-1020. Commissioner Demerson.
I agree in part and disagree in part with the staff recommendation and would rule that the mechanics and the first name consultant are in employment. The welders are not in employment because they own their own equipment, which by its nature is very expensive and shows that they have a major investment in their own business. They can and do work for other companies. They're free to accept or reject assignments. They pay their own expenses, and they do not work on a continuous basis, but rather only as a welding work arises on which they are needed as contractors. The electricians are not in employment because they work under similar conditions to the welders. The pipe fabricator is not in employment because he worked on one short-term project, did not have to perform the work personally, and was responsible for paying for his own helper. The CDL driver was not in employment because he did one short-term job for the company, hauling a large and heavy piece of equipment that required the driver's specialized truck and trailer. He was paid a fixed sum. And lastly, the second consultant was not in employment because he gives the company advice on a one-of-a-kind requiring specialized technical knowledge, works with several different clients, and is not available on demand to any one client, such as the named company. And so in summary, agreeing in part and disagreeing in part, would rule that the mechanics and the first name consultant are in employment. The welders, electricians, pipe fabricator, CDL driver, and the second name consultant are not in employment.
I agree with staff's recommendation.
Agree with staff recommendation.
I'm a short form dissent.
Yes, sir, Commissioner Demerson. The second case is TD-21-010-0421. Commissioner Demerson.
Agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
Mr. Chairman.
Agree with staff recommendation.
Thank you.
We have no fair housing cases under agenda item 5.
Correct, no cases.
On agenda item 6, we have no wage claim cases on docket 24 pulled for additional discussion.
That's correct. None pulled for discussion. You should have received the wage claim short form dissent list for docket 24.
I move we accept staff recommendations on the remaining wage claim cases on docket 24.
I second the motion except for those cases in which I'm dissenting as reflected on the wage claim short form dissent list for docket 24.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 24.
Motion passes with the exceptions noted. Let's move to agenda item 7, in consideration of unemployment insurance cases on docket 24. Please proceed when you're ready.
Case number 2632354, Commissioner Alvarez.
The decision should be modified. No misconduct, no chargeback, MBI. The claimant was on intermittent FMLA, and her final absence was caused by a side effect of her medication. As the claimant's absence was medically related, she should be qualified for benefits in the employer's account protected from charge. Modify the AT, no misconduct, no chargeback, MVI.
We should modify the AT decision, no misconduct, no chargeback, MVI.
I concur with Commissioner Demers.
Thank you. We have unanimous decision.
Case number 2650710, Commissioner Alvarez.
The decision should be modified, no misconduct, no chargeback due to disaster. The claimant was separated when she tested positive for COVID-19. She intended to return to work after 2 weeks, but she was still having symptoms such as high fever and cough. Therefore, her doctor recommended that she remain out of work. The claimant was separated when she stopped working and stopped being paid on August 5th. She filed her claim for benefits shortly thereafter. The AT decision and staff's recommendation incorrectly focused on events that occurred over 2 months after the claimant was separated and filed for benefits. As the claimant was separated at the time she became sick due to COVID-19, she should be qualified for benefits in the employer's account protected from charge due to disaster. Modify the AT, no misconduct, no chargeback, disaster.
The AT decision should be modified since the claimant stopped working when she tested positive for COVID-19. I would agree to qualify the claimant for benefits. The employer's account should remain protected from chargeback. Accordingly, we should modify the AT decision, no voluntary leaving, no chargeback, disaster.
Modify the AT, no voluntary leaving, no chargeback, disaster.
Commissioner Alvarez, the vote is unanimous that the claimant will be paid, but the majority vote is that it was a voluntary leaving.
I would agree with the majority.
Thank you, sir.
Yes, sir. Ma'am.
That's a unanimous decision.
Case number 2668405, Commissioner Alvarez.
The decision should be modified, no misconduct, no chargeback, MVI. The claimant had prior attendance issues, but his final absence was caused by his minor child's medical issue. The claimant's son has asthma and was exposed to COVID-19 at school. The claimant missed work with the notice to take his son to be tested for COVID-19. In accordance with case cited by the AT, as the claimant's final absence was caused by a medical issue of his minor child, the claimant's absence was not misconduct. Modify the AT, no misconduct, no chargeback, MVI on a minor child.
The AT decision should be reversed. The claimant continued to be absent from work without proper notice or approval after prior warning. The claimant's blanket denial of wrongdoing and his assertion that his absences were excused is not credible. The record established that the claimant signed the employer's policies and knew his poor attendance placed his job in jeopardy. Nevertheless, the claimant made no attempts to protect his job and continued to be absent without notice or permission. I would not agree to an MVI or disaster vote in this case because the claimant's child was not ill and neither medical reasons nor the pandemic prevented the claimant from complying with the employer's notice policies. The claimant failed to take adequate steps to protect his job and he mismanaged his position of employment. To reverse the AT decision, misconduct, no chargeback, adequate employer response.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2696185, Commissioner Alvarez.
The decision is not supportable. The claimant testified he encountered technical issues when trying to appeal online. He attempted to fax an appeal during the deadline, but did not know if it went through. The claimant's testimony is consistent with the information provided in the first appeal received by TWC. Reverse the AT, timely claimant appeal, remand.
The AT decision should be affirmed. The claimant's appeal is almost 2 months late, and he failed to provide any evidence of a timely appeal submitted by fax. Furthermore, any difficulty the claimant may have had in reaching the TWC representative did not prevent him from mailing or faxing his appeal before the deadline. Thus, the claimant's appeal is late, and we do not have jurisdiction to consider the underlying merits of this case. Accordingly, we should affirm the AT decision, untimely claimant appeal, misconduct, no chargeback.
Affirm the AT, untimely claimant appeal, misconduct, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2731310, Commissioner Alvarez.
The claimant separated from employment to care for her terminally ill spouse. The claimant has provided medical documentation establishing her spouse's condition and the care she provides to him. The claimant should be qualified for benefits under Section 207.046A3. Reverse AAT, no voluntary leaving, bill reimburse an employer.
The AT decision should be affirmed. The claimant resigned when she chose not to return to work after exhausting her leave. The claimant could have applied for additional extended leave, but she elected not to do so. Ultimately, the claimant failed to take adequate steps to protect her job, and none of the exceptions to disqualification under Section 207.046 of the Act apply to the facts of this case. As such, the claimant's failure to take adequate steps to protect her job constitutes a voluntary quit without work-connected good cause. We should affirm the AT decision, voluntary leaving, reimbursing employer, not billed.
Affirm the AT, voluntary leaving, reimbursing employer, not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2731701, Commissioner Alvarez.
The decision should be reversed. Only the claimant appeared to provide sworn testimony. The claimant's testimony established that the employer failed to follow basic CDC guidelines to prevent the spread of COVID-19. When the claimant brought his concerns to management, the only resolution offered by the employer was for the claimant to take time off, and then the employer filed the claimant's position when he took time off. The employer failure to comply with CDC guidelines provided the claimant good cause connected with the work for quitting. Reverse AAT, no voluntary leaving, disaster, no overpayment.
I agree with that. The AT decision should be reversed. Based on the facts of this case, I would agree to qualify the claimant under the disaster provisions of the Act. Accordingly, we should reverse the AT decision, no voluntary leaving, disaster, no overpayment.
Reverse the AT, no voluntary leaving, disaster, no overpayment.
Thank you. We have a unanimous decision.
Case number 2755707, Commissioner Demerson.
The appeal tribunal decision should be modified. The claimant quit her job in part due to a reduction in her work hours. Initially, the claimant worked full-time hours, but as she stated in testimony, that changed over time, especially during the pandemic. Based on the claimant's testimony, it is not unreasonable to conclude that there was a connection between the pandemic and the claimant's reduced hours. Accordingly, the claimant should continue to be qualified for benefits, and the employer's account should be protected from charge due to disaster. We should therefore modify the AT decision, no voluntary leaving, no chargeback, separation due to the disaster.
The AT decision should be reversed. The employer reduced the claimant's hours from full-time only to 10 to 12 hours per week. As a result, she did not earn enough money to pay for child care when her family members were no longer able to help her. She quit with good cause connected with the work as a result of the reduction in hours. Reverse AT, no voluntary leaving, chargeback.
Affirm the AT, voluntary leaving, no chargeback, memo to investigate claimant's PUA eligibility.
Chair, I'm going to agree with the chairman.
Yes, sir.
Short form dissent.
Yes, sir, Commissioner Alvarez. And we will send the PUA memo.
Case number 2768318, Commissioner Alvarez.
The AT decision should be reversed. The claimant denied using illegal drugs. The employer testified that it had a policy which called for termination for a positive drug test, but the employer's witness testified that the policy he had was from 2021, which is after the claimant was separated. The claimant presented the policy he had, which called for suspension. The employer's witness acknowledged that the policy calling for suspension when the employee tests positive, but he could not confirm when the corrected policy was distributed to employees. And there is no acknowledgement of the receipt for a later policy in evidence. The employer has also failed to produce a chain of custody form for a drug test. The evidence in this case is insufficient to overcome the claimant's sworn denial of illegal drug use. Reverse AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The employer discharged the claimant after a positive drug test result. The claimant signed the acknowledgement of the employer's drug test policy. While the claimant contends that the policy was not being followed, the employer provided sufficient evidence of the claimant's positive drug test result, and consequently work-connected misconduct. We should therefore affirm the AT decision, misconduct, no chargeback.
The employer failed to prove misconduct by preponderance of the evidence. Reverse the AT, no misconduct chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 2781984, Commissioner Alvarez.
The decision should be modified. The claimant was absent from work because she had COVID-19. Emails and evidence demonstrated that the claimant was trying to get her doctor to complete the FMLA paperwork, but the doctor failed to do so. The claimant was also on strict quarantine due to COVID-19, and she could not go to the doctor's office and pick up the paperwork. She was dependent upon the doctor's office completing it and sending it to the employer, which they ultimately failed to do. The evidence fails to establish misconduct connected with the work. Modify the AT, no misconduct, no chargeback, disaster.
The appeal tribunal decision should be affirmed. The claimant was on medical leave. The employer had notified the claimant that she needed to submit medical documentation pertaining to her leave, but despite multiple notifications and extending the deadline to submit the documentation, the claimant failed to do so. As such, the claimant's failure to follow the employer's instructions constituted work-connected misconduct, and we should affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form and memo to UI regarding PUA eligibility.
Yes, sir, have your dissent, and we will send that memo.
Case number 2787302, Commissioner Alvarez.
The decision should be modified. The claimant was the only party who appeared and provided sworn testimony. The claimant's sworn testimony established that the working conditions were unsafe. The employer failed to provide PPE and failed to enforce protocols to stop the spread of COVID-19. Workers were continuing to come to work sick, and there was an outbreak of COVID-19 in the claimant's work unit. The employer failed to address these issues when the claimant brought them to the employer's attention. Since the employer failed to resolve a legitimate complaint, she had good cause connected with the work for quitting. With regard to the availability issue, the claimant never indicated that she was unwilling to perform any work due to the fear of catching COVID-19. The claimant worked through the height of the COVID-19 pandemic in Houston. The claimant had a very specific concern about safety issues with her last employer. She was willing to work for other employers. Modify the AT, no voluntary leaving, no chargeback, disaster, claimant available for work.
The appeal tribunal decision should be modified. Regarding the job separation, there is sufficient evidence to show that the claimant separated from work due to the disaster. As to availability, the appeal tribunal decision to hold the claimant ineligible for the time period in question is supportable. We should therefore modify the AT decision, no voluntary leaving, no chargeback, separation due to disaster. Claimant not available for work from February 7th, 2021 through April 24th, 2021.
Can you tell me the two votes again, please?
Yes, sir. Commissioner Alvarez voted no voluntary leaving, no chargeback, disaster impacted, and reverse, so that there is no availability, ineligibility. And Commissioner Demerson agreed on the separation and chargeback issues. No separation, no chargeback, disaster impacted, but he disagreed and affirmed the availability, ineligibility.
Affirm the AT, voluntary leaving, no chargeback, claimant not available for work from February 7th, 2021 through April 24th, 2021.
Chair, I agree with the chairman. I think we're
Yes, sir.
agreed there.
So the majority vote is to affirm. That disqualifies the claimant and leaves the availability, ineligibility in place.
Short form dissent.
Yes, sir.
Case number 2788254, Commissioner Alvarez.
The decision is not supportable. The claimant was discharged because he was unable to make it into work as a result of the February winter storm. The claimant reported the situation to his manager prior to his shift. The claimant's absence fell during the declared disaster period, which the claimant Since the claimant's separation was a result of the winter storm, the claimant should be qualified for benefits in the employer's account protected from charge. Reverse AT, no misconduct, no chargeback, disaster.
The appeal tribunal decision should be affirmed. The claimant was discharged under the employer's attendance policy, of which he was aware. Since the claimant accumulated enough points under the employer's policy due to his attendance issues, his actions constituted mismanagement of his position of employment and misconduct connected with the work. We should therefore affirm the AT decision, misconduct, no chargeback.
Reverse the AT, no misconduct, chargeback.
Ms. Miller, if it helps, I'll agree with the chairman.
Yes, sir. The majority vote is no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 2796771, Commissioner Alvarez.
The decision should be modified. The claimant stopped working for the employer when first her parents tested positive for COVID-19, and then she tested positive for COVID-19 and had to be quarantined for 6 weeks. The claimant was separated due to the pandemic. Modify the AT, no voluntary leaving, no chargeback, disaster.
We should modify the appeal tribunal decision because the job separation resulted from the claimant needing to follow safety protocols after household members contracted COVID-19. The job separation resulted from the disaster. Accordingly, the claimant should be qualified for benefits and the employer's account should be protected from charge. We should modify the AT decision, no voluntary leaving, no chargeback, separation caused by disaster, void the adequate response ruling.
Modify the AT, no voluntary leaving, no chargeback, disaster, void, adequate response.
We have a unanimous decision. Commissioner Alvarez, you didn't mention it, but your vote would be consistent with voiding the adequate response ruling.
That's correct.
Thank you, sir.
Case number 2797811, Commissioner Alvarez.
The decision should be reversed. The claimant denied that she intentionally hired former employees of the client in violation of policy, and she followed the hiring procedure as she was trained. The employer alleged that the claimant admitted to intentionally violating the policy, but the employer failed to present the first-hand sworn testimony from the person who heard the claimant's alleged admission. The claimant's sworn testimony carries greater weight than the hearsay offered by the employer. The evidence fails to establish misconduct. Reverse AT, no misconduct, chargeback.
We should affirm, we should affirm the appeal tribunal decision. The claimant's fact-finding statements taken in conjunction with the employer's documentary evidence established that the claimant was aware of the employer's hiring policies, yet knowingly violated these policies. Because the claimant's actions jeopardized the employer's relationship with one of its largest clients, the claimant was discharged for misconduct connected with work. We should affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Ms. Miller, short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2799850, Commissioner Alvarez.
The decision should be modified. The claimant was the only party providing sworn testimony. The claimant's testimony established that the employer failed to follow basic CDC guidelines to prevent the spread of COVID-19. Workers on the premises were not wearing masks or socially distancing. The employer failed to take any corrective action after the claimant brought his complaints to management. The claimant had good cause connected with the work for quitting. Modify the AT, no voluntary leaving, no chargeback, disaster.
We should affirm the appeal tribunal decision. Because the claimant did not provide medical documentation that advised him to quit his job due to his family members' medical issues, the claimant's disqualification is appropriate. In addition, by resigning less than a week after returning to the office, he failed to provide the employer reasonable time to address any concerns he had with the securities team's alleged failure to follow safety protocols. Accordingly, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2801462, Commissioner Demerson.
We should reverse the appeal tribunal decision. At the time of the job separation, media posts from TWC and other state offices, in addition to information on TWC's website, notified employers that job separations filed due to the COVID-19 pandemic would not be charged to an employer's account. Early reports did not include many details about how eligibility for chargeback protection worked. This may have caused employers some confusion, and resulted in some, like the employer in the current case, believing that the chargeback protection was automatic. Because agency communication during the early part of the pandemic may have contributed to some employers being misinformed about their eligibility for chargeback protection, and this in turn affected their appeal rights, we should deem the employer's appeal timely. Accordingly, we should reverse the AT decision, timely employer appeal, and resubmit the case for merits testimony.
The AT decision should be affirmed. The employer failed to file an appeal from the determination in this case for several months. The employer did not reply to the misinformation provided by the state and TWC in filing a late appeal. While state and TWC websites state that the employer accounts would not be charged if the work separation was caused by the pandemic, that information is accurate. The employer states in the response to the notice of initial claim that the separation was a pandemic-related and commission personnel relied on the available evidence to rule on chargeback in this case. Assuming that the separation in this case was actually caused by the pandemic, the employer's account was charged because the employer failed to provide adequate response. Additionally, the determination on the appeal clearly stated that the employer's account would be charged, but the employer still made no effort to appeal before the deadline. The employer has not provided a basis for the appeal to be deemed timely. Affirm the AT late employer appeal, no misconduct, chargeback.
Under TWC Rule 8:15.32I7, timeliness sanctions shall not apply when an agency representative has given misleading information. Reverse the AT, timely employer appeal, resubmit.
Thank you. We will resubmit the case.
Case number 28044247. Commissioner Alvarez?
The claimant received the determinations electronically but was unable to file her appeal online because she was encountering technical issues with the system. She had difficulty contacting TWC via phone for assistance. Once she was able to speak with a TWC representative, she learned she could file at her local workforce center, which she did. Since the claimant's delay in appealing was due to TWC systems issues, her appeal should be deemed timely and case remanded for merits. Deemed timely and remand.
We should affirm the appeal tribunal decision. The claimant opened the determination at issue the day after they were sent to her. Even if the claimant had problems filing her appeal online, she could have filed her appeal using any of the other acceptable methods outlined in the determination. As there is no good cause exception to the timeliness rules, we do not have jurisdiction to consider the underlying merits. Accordingly, we should affirm the AT decision. The claimant filed a late appeal, misconduct, overpayment of $782.
Affirm the AT, untimely claimant appeal, misconduct, overpayment.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 28064006. Commissioner Alvarez?
The claimant is the only party to provide firsthand testimony regarding the final incident. The claimant has denied the employer's allegations that she failed to wear her seatbelt. As the employer has not participated in the hearings to rebut the claimant's denial, the employer has failed to provide sufficient evidence to establish misconduct. Reverse AT, no misconduct. Alternatively, I could agree to a rehear. The employer has provided still images alleging to show that the claimant not wearing her seatbelt. The images are of too poor a quality to establish the claimant failed to wear her seatbelt. I would agree to a rehear for the employer to provide clear video or photographs of the alleged incident.
We should affirm the appeal tribunal decision. The employer submitted documentation and photos of the final incident. These established that the claimant was not following the employer's seatbelt and face mask procedures after prior warnings. Accordingly, we should affirm the AT decision, misconduct.
Affirm the AT, misconduct.
Short form dissent.
Yes, sir, Commissioner Alvarez. And that was the last unemployment insurance case pulled for additional discussion on docket 24. You should have received the UI short form dissent list for docket 24.
I move we accept staff recommendations on the remaining UI cases on docket 24.
I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 24.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 24.
Motion passes with the exceptions noted.
Thank you very much.
Thank you. Just going to take a quick break while we get ready for the rest of the meeting. we're back. Let's go to agenda item 8, COVID childcare state waiver.
Good morning, Chairman, Commissioners, Mr. Townsend. Reagan Miller with the Child Care and Early Learning Division. This morning for your consideration is a state waiver to modify TWC Rule 809.41 to allow for initial job search for individuals applying for child care subsidies. During COVID, we've seen many parents who have lost employment and who are expressing a need for child care in order to look for work. We've also heard this is a concern from unemployment insurance claimants. With this proposed rule waiver, parents who are unemployed could be determined eligible for child care and would be provided up to 3 months to find employment. Following 3 months, if they are not meeting the child care work activity requirement, then their child care would be terminated. One of the issues that we needed to carefully consider was how to handle the parent copay. Under the federal regulations, we are not allowed to increase the parent copay during their 12-month eligibility period. And because a parent could be entering with no income, their initial copay could be set at 0. And once they secured employment, we would not be able to adjust this amount upward. Based on guidance that we received from the Federal Office of Child Care, we will be able to address this. We will direct the boards to set the parent copay at the maximum possible amount for that family size, and then immediately waive it during their job search period. Then, at the time the parent becomes employed, we will reinstate the copay and will review their actual income and adjust the copay downward as needed. Based on this, we're requesting your approval to waive TWC's child care rules 809.41A3B as described in the discussion paper to allow unemployed parents to be determined eligible for subsidized child care for up to 3 months. And I'm happy to answer any questions.
Comments or questions?
None here, Chairman.
None.
Do we have a motion?
Chairman, I move we suspend 40 TAC 809.41 A3B through BUCY 2022 as recommended by staff.
Second.
It's been moved and seconded. We're unanimous.
Thank you.
Thank you. Move to agenda item 9, 2021 unemployment insurance tax rates.
Good morning, Chairman, Commissioners, Mr. Townsend. For the record, Chris Nelson, Chief Financial Officer. On June 8, 2021, I presented to you a discussion paper regarding options for setting the 2021 unemployment insurance tax rates. While the options laid out in the discussion paper were correct, I did provide incorrect information from the dais. This morning, I would like to correct that information and see if the Commission would like to change their action regarding this corrected information. Last week, I stated the obligation assessment is experience rated, meaning it only applies to employers with effective charges in the last 36 months. That interpretation is incorrect. The obligation assessment applies to all employers eligible for an experience rating, meaning even those employers with an experience rating of 0 would be assessed the obligation assessment if approved by the Commission. The impact of this corrected definition applies to the action the Commission took regarding the replenishment tax. In the discussion paper you have this morning, if you were to choose option 1 of setting the replenishment tax to 0.18%, the deficit tax to 0%, and assess the obligation assessment of 0.03%, then all employers eligible for an experience rating would have a minimum tax rate of 0.31% when adding the ETI tax of 0.10. Employers that pay the maximum rate would have the maximum rate of 6.31%. These would be the same minimum and maximum rates under the 2020 tax rates, and approximately 71% of all taxable employers paid either the minimum or maximum rates in 2020. And as previously stated, most employers already submitted their 2021 first quarter taxes without official rates, and analysis shows many paid using the 2020 tax rates as a basis. There is no change to the presented deficit tax information that was provided. If the Commission does wish to take action regarding this information, I would recommend that a vote to withdraw any action on June 8, 2021 unemployment insurance tax rates and revote each decision from the discussion paper again so the entirety of the Commission's intent is clear and documented in one Commission meeting. That concludes my comments, and I'd be happy to answer any questions.
Any comments or questions?
None here, Chairman.
None.
Do we have a motion?
Okay, thank you, Mr. Chair. And Chris, with the clarifying information provided, I move that we withdraw the actions on this item taken by the commission on June the 8th.
I second that motion.
It's been moved and seconded. We're unanimous.
Mr. Chairman, I further, in accordance with the authority granted by the Texas Labor Code, Section 204.067, I move that the Texas Workforce Commission adjust the replenishment tax rate for 2021 to 0.18%.
I second the motion.
I agree.
We're unanimous.
Mr. Chairman, in accordance with the authority granted by the Texas Labor Code, Section 204.067, I move that the Texas Workforce Commission adjust the deficit tax rate for 2021 to 0.
I second the motion.
Chairman, I agree.
All right, we're unanimous on that one.
Good. And lastly, in accordance with the requirements of the Texas Labor Code, Section 203.105 and TWC Rule 815.132, I move that the Texas Workforce Commission set the unemployment obligation assessment rate for 2021 to 0.03%.
I second the motion.
I'll agree with that as well, Chairman.
Yeah, we're unanimous.
Thank you.
When is the first payment due?
I believe the first payment is due August 2nd.
Okay. Thank you.
So-
All right. Thanks so much. I don't think we have anything under agenda item 10. It's my understanding. Do we have anything under agenda item 11, our standing COVID report? No. Anything under agenda item 12, legislative proposals? Nope. Is there a legislative report today? Nope.
No.
Yeah, he already said no, but I was going to let you overrule him if you wanted to. It's up
No
to
need.
you. Do you want to do an executive director's report?
There's no director.
No executive director. This is your chance to get some things off your chest.
Do it, Randy. Do it, Randy. Do it, Randy.
No, sir, nothing's.
He seems content. We'll leave him alone for
Mr. Chairman,
today. Is there any other order of business that needs to come before the
I
commission?
think I had a question for Randy.
Oh, you go right ahead.
I withdraw.
You withdraw your question.
Say it, Randy.
Thank you.
I mean, we could vote to reinstate your question on the Saturday, but I don't think we're going to. Any other order of business come before the commission?
None here, Chairman.
None. Thank you.
Do we have a motion to adjourn?
Chairman, I move that we adjourn.
Second the motion.
It's been moved and seconded to adjourn, and we are adjourned. Give us a few minutes, and we're going to do a work session here and talk about some interesting and exciting things. I'm gonna save those for later. Oh, I see. I don't know a lot of things, but I have found in life that next slide usually gets the job done. I don't know about that, because I don't know how that's gonna look on camera once we get done for the day, so. You guys ready to start? We're ready. All yours, Mr. Townsend.
Good morning, Mr. Chairman, Commissioners. For the record, Randy Townsend, Deputy Executive Director. For the work session this morning on the development of more meaningful performance measures for the Texas workforce system, we have a little presentation this morning. We have Courtney Arbor, Reagan Miller, and Adam Leonard available as staff resources this morning, and I believe Courtney is going to start off with a brief presentation, and then we'll take it from there.
Randy, are the mics all on?
The green light's on, but
All right.
they're not broadcasting.
Okay, I'll start. Good morning, Courtney Arbor, Workforce Division. Commissioners, in May, you all asked that we bring information forward about some performance measures that you all could consider. We've briefed offices on some of these ideas, and we wanted to share them with you today in the work session. What we've attempted to do here, and we'll go through some slides, is to not only provide you information about some measures that we believe would be good for the workforce boards as contracted measures, but also explain some of our statutory requirements and what we believe that you would like to see, or start some conversation with you about what we think you would like to see in the measures locally that both meet our compliance requirements and also measure and help us to tell the story of what it is we do as a system in a way that makes more sense sometimes than some of the contracted measures that come. So I'll go ahead and start by sharing just a little bit about the current landscape for performance. As you're aware, and we've briefed your staff on this, Commissioners, we have a number of required measures that the boards are responsible for currently. Many of those are required by Department of Labor. We have a number of WIOA measures that are defined in statute and regulations, and they're mostly exit-based, and as you know, there's a significant lag to some of them because of the way the wage system works in most states, including Texas. We have 3 integrated WIOA measures that are based on the General Appropriations Act. We have a Choices Full Work Rate, which is actually a TWC-created measure that we contract down to the boards, and it's a little different, but it meets the requirements of a TANF federal participation rate. It's not exact to what the feds require, but it's within what they expect. We have the claimant reemployment within 10 weeks that the boards are contracted to perform. And I believe you're aware that's a TWC-created measure. It was done a few years ago. Adam will talk a little bit more about some of the history on these, but it was created to help make sure that we put a lot of focus on making sure that claimants get back to work in a short period of time. We have a number of employers receiving workforce assistance. That was a TWC-created measure, and I've been jokingly saying that people in DOL like Adam so much, we think it'll probably become a WIOA mandatory measure as it has proven to help the state really focus on services to employers. And then we have the average number of children served per day, which is based on a GAA measure. The Workforce Division is also responsible for 3 Wagner-Pizer measures. Those are also defined in WIOA statute and regulation, 5 adult ed measures, WIOA effectiveness in serving employers, which is DOL, and Department of Ed are working on that one. TANF participation rate, as I mentioned earlier, is in federal statute. And then we have 3 to 4 SNAP and WIOA-based measures that are underway. So many of those, as you hear, are either state or federally required. And while we will always have those measures, we have some flexibility in how we develop either other measures or how we adjust within the requirements under law and statute to get more meaningful measures in what we contract. So when we were looking back at the measures we have in place currently, we all took a look at the mission, vision, and philosophy of the agency to try to let that and the comments we've heard from you in past months really drive the way we were thinking about these recommendations. The mission clearly states that we want everyone to have the opportunity to achieve and sustain economic prosperity. So that a lot comes with that, right? You have to really think about what kind of behaviors you want to incent and drive when you're thinking about true economic prosperity. Highlighted there, you'll also see that we say we want Texas forever, a skilled workforce for every employer, a job for every Texan who wants one. And so we thought about that as we brought these recommendations. And then last, the flexibility, innovation, and learning, driving responsiveness. And what stuck out to us there is continuous improvement. Texas has a long history of adjusting, TWC has a long history of adjusting measures to try to do what we believe is best for the boards, that's not overly onerous, but also drives the kind of behaviors we want to see locally so that they are paying attention and their contractors are paying attention to those that we, as a system, say are of value in our philosophy. So I'm going to turn it over to Adam to talk a little bit about how these measures line up with that, and then what some other good measures may look like.
So when we think about how the current measures, as they exist, their strengths and weaknesses, we realize that they don't help us communicate some of the most important things about our system. They don't help us answer questions like how many people found new jobs or how many employers found new workers. How long did it take them to find these workers or to find these jobs? Are they remaining employed? Are they staying with the same employer so that we know that it's kind of it was a good hire or a good application? What's happening to their earnings? What are we doing in terms of setting people up for the future? And then the other piece of it is when you look more directly at the way WIOA was structured and their measures, they basically reward what I would consider to be a failure in certain circumstances. So if we have a person who's already employed and who comes to us looking either for a new job or for a second job, and who ultimately gets, shall we say, frustrated, they don't have success, so they just stop looking and they stay at the old employer. Well, as long as they're still employed in quarter 2 after exit and quarter 4 after exit, WIOA says that's a good job. I don't think the job seeker would really think that that was a very good job because they came to us looking for some additional assistance finding either secondary or new employment. And a lot of that has to do with this idea that they focus on any employment or any earnings, including that which you came in with. And so these are areas that we really felt needed to be looked at for the future. And so, well, what would we do to make good measures? Well, good measures would ideally be aligned with the needs of our customers and our system's priorities, being built around the types of services we're providing, so the way that we're investing in them and working with them. We need much more timely and actionable data, right? The data that the WIOA measures currently provide is 12 to 18 months after services conclude. So you could have been in the program for a very long time, not necessarily in training, and yet, you know, it still keeps going and going. And as long as you're employed in quarter 2 or 4, that's considered successful. So this is kind of a driving beyond or faster than your headlights situation that by the time we see what's coming, we've already lost the time to brake and to change direction because we have so much lag in there. We also realize that there needs to be more of a quality component to these measures. So timeliness is all very well and good, but it should be timely good results, right? Timely quality results. Focusing on not just the WIOA definition of participants, but even those people who are minimally served. Like maybe somebody came to us and we taught them how to use work in Texas and we taught them how to find other job boards that are specific to their occupation or industry. And then the next time they came back to us, they were able to completely self-serve because we had taught them how to do those things. WIOA doesn't look at that. So ultimately, going forward here, what we decided to do is to try to focus on kind of shorter and medium-term measures to focus on accountability and use longer-term measures conceptually to help us evaluate the system and communicate effectiveness over the long run. And ideally, try to develop measures that we felt were going to positively influence our system and our partners' behaviors so that that doing the things that are in the best interest of the customer are the things that are going to result in, you know, are going to reflect well in the performance so we don't have these weird situations that we have under WIOA. We do have a lot of experience using measures to drive change, and here there are 3 examples. In 2003, we had a system where people were asking the question of if we're a demand-driven system or an employer-driven system, what are we measuring that matters to employers? We didn't have any measures to speak of that looked at that. And so two ideas came to the forefront as the strongest ones that have had the greatest legs. One has to do with reemploying claimants rapidly, with the idea that ultimately that's good for both the job seeker and the employer, given the experience modifier situation. And so just by creating a measure and giving the boards responsibility with increasing targets, we were able to see performance go from prior to the measure at 28% of people being reemployed. In the first year, jumped to 40% being reemployed within 10 weeks. And then the second year, we were at 50%. And then we bounced around until the Great Recession between 55 and 60%. So we were having a lot of success there. And that's just a matter about creating a measure with accountability and getting people oriented around it, giving them some tools to help them manage it. And the same thing with employers receiving workforce assistance. Before we had those measures, we were serving 30,000 out of about 500,000 employers a year. In the first year, that roughly doubled. In the second year, it went up 50%, which means another 30,000. So we were up around 91,000 in there. Again, it's all about communicating what we really want and building measures around it. And the most recent example of this had to do with our choices for work rate, where we were reducing the administrative burden of tracking people in seats looking for jobs and focusing more on the employment outcomes. So how much time people actually spent meeting their participation through subsidized, unsubsidized employment, on-the-job training, or high school for teens who had not completed it yet. And again, we saw significant improvements in performance in there, to the point that in the third year, we had 18 of 28 boards were above 50%. We told them in advance that we wanted to get to 50%, and we stair-stepped the targets over several years to get there. So, ultimately, just as a aside there, we've talked about this measure in March when I was presenting targets, that if we want this program to promote some more innovative activities, we need to count some of those activities in the measure, and so we're looking at that as well as a separate issue. So next slide, we're going to now kind of shift, and Courtney's going to take back over and talk a little bit more about the future landscape, where we see things going, and some recommendations for measures.
Okay. On this next slide, it's a bit redundant to what we've already said. There will be statute and regulation that drives some of our measures. We work within and sometimes in addition to those to, as Adam just described, to make sure or to try and get the performance out of our system that we'd like to see and that we know benefit employers and Texans. And with everything that's going on in our economy now, we are hoping that some of these recommendations today will resonate. On the next slide, Adam talked a little bit about how he doesn't use the term light touch, but that's sort of the way I talk about it. In our system, we do a lot of we do a lot of program work where you case manage and you provide training and support services. But far more often, we are helping people learn how to look for work, helping people that are looking for their first-time job fill out applications, answer questions about felonies in interviews, dress for interviews, understand what employers are looking for, not just on the technical side and pointing them toward technical skill, but also teaching people, often young people or those that have been out of the workforce, what employers really look for when you're in the interview, when you get the job. And so we are really thinking of both employers and job seekers and employers with two types of ways of thinking now. Some are more light touch and just need some basic information to get moving. Others need a little more of a lift. Employers need sometimes more light touch or want light touch, and then others want a little more help. So here we talk about the services for individuals. We'll call these, and these are all services that are already in existence. They're used in Work in Texas and TWIST by boards currently. I know that's something that the boards will be interested to hear if they're listening to this work session, but really we're just categorizing them differently and pulling those services into a denominator for certain measures where they might sit squarely in one measure. We'll use them as a denominator for other measures now too. Employment connection services are those that I was talking about that I would consider more light touch. Hundreds of thousands of people use Work in Texas, come to orientations at the workforce centers, attend hiring events, virtual or in person, come to events that even other community partners come into the one-stops to recruit for different types of services. And so people use the one-stops really as a one-stop. And so we're looking at the different services that happen in our interactions with those customers and considering those employment connection, helping people find their new or secondary employment. Others need what we're calling employability services to really succeed or build a skill. They may need childcare. They may need other support services or training, whether it's an online learning or it's a classroom training through one of our eligible training providers. But this customer group has identified, either because they didn't quickly go into work or because through our case management process we recognize they need more help, that we're looking at this level of service as more of an employability service. For employers, same idea. Some employers come to us saying they want information about work opportunity tax credit, maybe bonding. They want to post their jobs and work in Texas, or they're doing a layoff and they need rapid response help, which means our staff go in and help move those job seekers into other opportunities. Other employers, as you know, come to us for skills development fund or skills for small business or incumbent worker training through the workforce boards, but they're looking for something more substantive than, albeit important, the job pipeline work that they are often looking for. So employment connection services for employers versus workforce employability services, same kind of category depending on what the employer says that they need. And ideally, we are hoping, or what we've been working toward is building measures with those groups in mind and try to measure direct behavior in those ways so that we're doing more of them, and then measuring the outcomes of those services provided to job seekers and employers, and then using that information to better tell the story of what it is we do, how we do it, how successful we are, and how those that come through our system may have a different outcome than those that don't interact with the workforce system. Albeit some of the work seems small, it's still meaningful because there are people helping others to get through whatever they're looking for in this workforce system. So we're looking at a number of short-term measures. One is the connection rate. Talked a little bit about connection services. That would be the job seekers with a new employment connection or who move to employability services within a certain period of time. We'd like to start measuring those who get a job, how quickly they do, and if our system does a good job of identifying people who may be struggling to find employment and moving them into a higher level of service. Honestly, I believe this does go very well in many of our board areas already, but we don't measure it this way, so we think that promoting this as a measure will help incent more of that behavior and the type of follow-up that our boards do to help push people into those employability services if they're not finding success quickly and finding a job. Number of employers hiring TWC job seekers, and then there are a couple of child care measures that I'll turn over to Reagan before I pick up the short-term measures.
So, with the action that you just took, authorizing initial job search, we have another really good opportunity to illustrate why it makes sense to have childcare in a workforce agency. As we talk about employment connections, this is an opportunity so when those folks are coming in, applying for childcare, and in that initial job search period, for the childcare and the workforce staff to work together to help link and help that customer find good employment. We've talked a lot about direct connections and reconnections, because we also provide childcare for a 3-month period if you lose a job. So all of those workforce resources that are available to job seekers should be deliberately and strategically made available to childcare parents who are either applying for childcare or who have lost their job while receiving childcare. This was one of our sunset recommendations years ago. How do you do a better job of connecting these two services? And this is a perfect opportunity as we think about broadening these measures to really focus on this population as well.
Thanks, Reagan. And I should add that when we've talked about all of the measures we're talking about today, we consider all of the child care families as part of the denominator on these measures. We are really working to ensure that all the services provided to everyone who walks through the door, including childcare as a subset of that, is part of our measurement and can be pulled out to see how those families fare in the services they're receiving through the workforce system also. So the last short-term measure I'll mention before I move to some of the medium-term that we've been considering is a direct connection rate. That's for all customers. New employment connections between TWC employers specifically and job seekers where there was a referral. So we want to look at all of the activity, the outcomes of those who are, the connections of anybody who is using our services, but also look specifically at TWC employers, and when a referral was made specifically to that employer, how well does that connection piece seem to work, which would be a way to judge the quality of the referrals made and the quality of the job orders posted in the system, and how well we're doing at matching those folks up. A couple of medium-term measures, if you're ready for me to go on. Maintaining employment connection rate. Adam said it perfectly earlier. We want these matches to be quality. It's good to get a job, but most people want to keep the job and be in a career, Commissioner, as you so often say. So we're recommending looking at those new employment connections that are maintained through the next 2 quarters, and also to measure against others. How, in our system, what does that second quarter look like in comparison to others?
No, I was just going to say, we've been kind of monitoring this informally for a while using wage records, and so what this measure is aligned with this construct that would allow us to see whether our connections are lasting longer than an industry as a whole, or even for some of the larger employers, as a way to either market kind of our successes and try to encourage folks to want to work with us, or where our performance is lacking, and have a conversation with representatives of those industries to understand what it is that they're looking for that we're not quite providing in some of our job seekers, to see if we can improve. So it's really like the first measure that is kind of tied to objective reality, to the marketplace, as evidenced by the behavior of employers and job seekers.
Thank you. And then earnings impact, Adam mentioned this also, looking if we're going to look at the connection rate and how long people are staying with the employer that they were matched with through our system, what do the earnings look like, particularly those that are trying to transition to a job? What does the earnings change look like over time in comparison to where they were before coming into our system? What were those wages before and after? And then for those who are trying to be reemployed after being laid off, then what is the earnings replacement success that we're having as we go out and do rapid response activities with employers and try to help place those laid off workers in other jobs? And just frankly, even if there is no rapid response activity, we'd like to see how well we're doing in helping workers get to a level of income that is similar to or higher than what they had previously. Last, the long-term measures that we would mention. There is a child care quality measure that I'll hand off to Reagan in just a second. But also we would like, and Commissioner Demerson, I know you've mentioned this recently, about looking long-term at outcomes. Chairman, I believe, actually, I think I've heard all of you say this. We'd like to see long-term what the outcomes are, not just second quarter, not just fourth quarter, but what really happens to people after they've engaged with our system and had some of these employability services. Did we give them a lift and the tools, both the technical skill and transferable skills, that help them to stay employed for the longer term? So we'd like to look at quarter 4. We'd like to start with looking at employment sustainability through 4 quarters, which we do now, a version of that, but we'll slice and dice it a little differently based on all we've said today. And employment stability. The employers that how are we working with employers, and Adam may have some to add to this, but how are we doing in serving employers, and are they keeping the workforce that we refer to them and provide job matches for? Looking at earnings year after services with us, and as long as 1, 3, 5 years with the data warehouse and the work that's happening there, we'll be able to gather information for longer term study of the outcomes of these customers beyond what we have currently, which is those quarter 2, quarter 4 common measures. Reagan, before I hand it back to Adam for any other comments,
Yes. And so you'll also see a long-term measure on TRS program growth. I'm sure, as you know, there's been some legislation around centralizing Texas Rising Star assessors, so the measurement of that quality standard eventually will be centralized in an entity serving statewide. There's also legislation to potentially make Texas Rising Star mandatory. But even without that legislation, the Commission already had an emphasis on increasing the number of programs participating in Texas Rising Star and on improving the quality of childcare that all of the children that we're serving are able to participate in. But since 2015, we used to have about 15% of our providers as Texas Rising Star. Now we're up to, probably almost a third, and over 40% of the kids in quality settings. We know that quality helps improve kindergarten readiness, and that's our future workforce that we're talking about. So as we continue to look at improving the quality of care, setting some deliberate measures to really gauge our success in increasing the number of quality child care providers and kids in care is certainly an area of interest.
The only thing I would add to that is it's not just, it's an interesting area for measurement because it tells a story beyond just the kids we put in care, right? So right now we've been running 120, 130,000 kids per day that we're subsidizing, and as Reagan mentioned, that's 15% of the kids in Texas. So what about the other 85%? Well, those who are going to TRS providers, they are benefiting. So we're benefiting, we are impacting far more than just the families that we directly subsidize with quality care and helping, that broader preparation. So it's an exciting area to kind of emphasize in what we do.
All right, thank you. Commissioners, any comments or questions for the group?
Great presentation. I do have a few comments, if that's okay, Chairman.
Absolutely.
Adam, I have, so I got a couple of things in my, as you can see from the dais, I have paperwork everywhere that I have some things that I'm going to reference that took place, and I'm glad that, Reagan, that you referenced the sunset recommendation in 2015. As you know, a commissioner back in October of 2016 made a recommendation from the dais that we look at the recommendation of what the Sunset Advisory Committee had brought forth. And so before I get into that, there are a couple of things that I'd like to ask, and one of them would be, Adam, would it help if we could associate occupational codes with wage records?
It would be, we could look, I'm all about the data, right? So, whatever data I can get my hands on that's reasonably easy to obtain, we can do valuable things with. I know that that's been a little bit of a holy grail within the evaluation of program effectiveness world. And in fact, there was some legislation that kind of pointed us in that direction a little bit, but it wasn't funded. So I don't know what the answer is beyond saying that if you give it to me, I can do some really interesting things with it, and I know that LMCI can as well.
So if I may, the recommendation Sunset Advisory Committee presented to the Texas Workforce Commission, as Reagan referenced, recommendation 5.1, TWC should consider at a minimum the financial and other impacts of employers reporting the additional information based on their size, overall cost to TWC to collect and analyze the additional occupational information. Limitation in collecting and analyzing the additional information and benefits to having the additional data and potential uses, including matching the occupations to educational outcomes beyond career schools. So this was particularly on the recommendation, on the section of when we were discussing career schools at the time. The other thing I'd like to bring out, if I may, Chairman, on page 9, if we could go to page 9, if the audience would love to see that. The two primary service types for employers. Courtney, you referenced, here is, you asked us what we would like to see brought forth or what we would like to see going forward. I appreciate the fact that you referenced some of the services that the boards provide. They do an amazing job of providing these services, and the relationship that we have with employers is exceptional. They've done such great work. Personal experience, yesterday I had an opportunity to visit with one of the boards, and we presented a grant, I want to say a TIP grant to Central Texas. And so with the help of the co-located educational specialist, that wasn't referenced here, and how we're marketing some of the programs that we have. I think Charlie Ayers does a great job in his office. So my question is, we would want to make sure that we are measuring business services outreach to employers regarding skills development, TIP, high demand, and apprenticeships to train new and incumbent workers, as well as the board's outreach regarding, it's something you didn't reference, but you did kind of, and that is fidelity bonding. WOTC, and now the apprenticeship tax credit that was just signed by the governor. I think that's important for our employers to know. And of course, something that you referenced, and that was shared work as layoff aversions for downsizing services. Those are important programs. I know while Commissioner Demerson was overseeing the Office of Employer Initiative, and I know that during the time of pandemic, with the help of Mary York, shared services seemed to be something that was very catchy. And so just being able to share this with our boards, I think is really important. And so that's what I have to say for page 9. If we could go to page 10, Chairman and Commissioner. On page 10, there's a section, short-term measures. My question is to all of you. Can our existing IT systems capture any of this data? What about real data? What would we need of any IT systems, Randy? Would we need anything to upgrade our current systems now? And again, I'm referencing what you just laid forth, Adam, and of course the recommendation by Sunset.
Well, obviously, if you're getting back to the sunset recommendation for getting occupational data, there would be IT implications because there's no field that exists within the wage record structure to report it. So there would be some work that would have to occur there. The remaining, the measures as we presented them as ideas, we can operate them with data that we're currently collecting without additional significant change in what the boards have to report. There are ways in the future where that could get better with additional information about hire dates, or if we were to be able to use National Directory and new hire data for more than just certain programs. There are ways we could do that. But otherwise, the data we need to do this is basically in the data warehouse now. And so it's just a matter of mining that data, setting up reports, analyzing it, and coming back with recommendations for more detail of how they work and what we should do as far as setting targets in the short, medium, and longer term ranges so that people have a sense of where we're going.
Thank you, Adam. So with that said, Randy, I'm going to ask for your help on this. Randy, can we look at or have a discussion paper regarding the collecting and associating occupational data with wage records? So I know back in 2015 we did a survey. That wasn't the collection of the data that we received of the surveys. The response was low, but I'd ask if you could look at that for us.
We can take a look.
Thank you, Randy. If I may continue the same page on page 10. Should there be a performance target for wage credential gain for parents of subsidized children? Reagan, great report, and love what you guys are talking about, and love what Adam has stated in the past, and that is, Adam stated earlier that we are not just educating our child or children, but we should also be educating our parents. So I love that. It's not just providing these individuals that are receiving subsidized child care with a job, but it's a career, a long-lasting career. I feel personally, by listening to some of the stakeholder meetings that I've been involved in, Reagan, that children tend to follow what their parents do. And so if we see parents succeed in programs that will benefit their livelihood, I'll give you one example, an apprenticeship program where parents are right away not only receiving a salary, but also receiving benefits and insurance. I see there's a huge plus in something like that. We need to measure the board's performance regarding placing parents receiving subsidized care into meaningful employment. Again, stressing meaningful employment, connection, or training. Make sure not just to place them in low-wage jobs. Nothing wrong with working at some of the jobs that were referenced by the commission early or by you all, but meaningful jobs. These low-wage jobs, otherwise the families never cycle out of child care subsidies, subsidized child care. Connect parents with opportunities like registered apprenticeship programs, as I referenced earlier, where they are working from day one. This makes room in the system, and again, ultimately, my goal is to make room in the system that we may be able to help future families so that we can get children out of subsidized child care. So those are a few of the comments that I have. Of course, I'd like to also reference on the Sunset Report back in 2016, specifically to address child care. issue 4, on, again, issue 4, 3.6, the agency measures effectiveness primarily in terms of the number of people served and average cost with no debt analysis of employer outcomes or comparisons to effectiveness of local boards' policy and management of the program. So again, Reagan, I appreciate the work that you and your team have done to listen to some of the recommendations that have come from the office. So I appreciate that. Randy, I think I was clear on what I'd like to see on a discussion paper in the future. And again, these were just some of the comments that I have regarding the presentation that was made before us. So good job by all of you. That's the end of my comments for right now, Chairman.
Mr. Chairman, just a few. I love the fact that we're doing the development of more meaningful performance measures for the Texas workforce system. And this allows us to really begin to shape measures that allows us to tell a story. And I think that's where we're headed. On page 2, Courtney, you mentioned something in regards to flexibility and the like. And can you kind of speak a little bit to that flexibility and then also the tri-agency task force that's mentioned here? I know we'll have legislation coming from there, and that may mean new measures as well. So kind of briefly touch base point on those two things.
Yes, Commissioner, the talk here about flexibility is trying to read what the statute and regulation tells us, and in light of our mission and vision, and we've hoped to provide you with some ideas here of how we exercise the greatest flexibility within the boundaries that they've created. The tri-agency bills do provide some guidance to all of us to start looking differently at career pathways, working together for career pathways, coming up with some common definitions of success among the agencies. And so we have a number of different tri-agency work groups. They're working on different things right now, but this work will start soon with the data folks and the program people all coming up with some shared measures or shared definitions of what we believe are of value as, again, storytelling and also helping to promote the right services and behaviors.
I love that common measures of success and common sense measures that it really allow us to tell a story. On page 5, talks about the minimum incentive to improve self-service twos if these individuals are excluded. What's an example of minimum incentives for individuals? That's on page 5. So this focuses on all types of customers, not just participants. Minimum incentive to improve self-service twos if these individuals are excluded.
If I might, what we were looking at in there is the sense that we've invested in work in Texas. We continue to look for opportunities to improve it through My Texas Career and such. But under the WIOA measures, people who purely self-serve or receive nothing other than basic informational services are not considered part of the programs. They're not included in outcomes. So if you don't, quote, get credit when these people have success, if that isn't reflective of your system, then what's the incentive to make that system better? And what's the incentive to work more with employers to put good jobs into the system so that you get into a positive feedback loop where people want to come back, they're able to find good jobs, employers find good workers, therefore they give us more good jobs, et cetera. So that's really what the idea behind that statement was.
Okay. That makes sense to me. I mean, that you definitely want to be measuring all those individuals and then providing opportunities for them to take advantage of those resources that are out there.
A good visual for what happens in our system is like a funnel. There are so many people getting these basic services, but meaningful services. And then in performance, what happens is only those that get into this more narrow type of services that are not exact to the term employability services we used earlier, the training and support services, but similar to that. There's a lot of people that are served and helped, but the measures tend to cut those out and only focus on this smaller group that gets level 2 type services. And the idea here, like Adam just said, is to help measure both so that even those that are looking for light touch, if they don't get into a job quickly, that we start building systems that identify that and help them move into the other level of service.
Yeah, and that's a point. I remember coming from a trip in the Valley, and I was at one of the border check points, and coming in, and a trooper kind of asked where you work, and I gave him my card at the Workforce Commission, and he referred back to the fact that when his start of his career was with the Texas Workforce Solutions Office there in the Valley, and look at where he is at this particular point, but had fond memories of that being his first point of contact. Not sure if he would have narrowed down into that smaller funnel, probably not a touch point that was there, and look at where he is at this particular point. So that's important for us to do that as well. Adam, you kind of talked about provide timely, actionable information. You can't monitor or improve if it takes 12 to 18 months to get data. Somebody kind of talked about that, and so we kind of talk a little bit about that, or anything we can do to get that data quickly.
So the federal measures, by focusing on quarters 2 and 4 after exit, mean you're waiting till quarters 2 and 4 after exit before you actually kind of have the opportunity to know whether you had success on those measures. And again, as we talked about, you could have that person doing job search for 5 years, and as long as they're employed in quarters 2 and 4 after exit, that's considered good. So you don't kind of have visibility on the fact that you might have a population of people who are kind of languishing in the system, and so you have that lag. The other part of the lag is kind of worse, because you go, well, quarter 2, that sounds like 6 months, right? Well, because of the way that the scheduling was set up by the feds for reporting, which is based on when employers filed paper wage records back in 2000, they assume that it takes 7 months and change before data for a quarter of wages becomes what we call mature or complete. And we've been monitoring this in Texas, and since I want to say somewhere in the 2011 to 13 range, we've been 99% complete within 90 days after the end of the quarter, which means that we don't have to wait for our measures. We don't have to wait until the feds tell us it's time to report them. We can go ahead and start running things a lot faster. So it's still a 90-day wait to see what happened, or 75 to 90 days depending, but that's a heck of a lot better than 12 to 18 months.
Yeah, so continuous improvement in that area is something that works,
Right.
and quite often we have a Texas way of doing things, and so let's continue in that vein. And lastly, you guys talked about the wage data, and so you know how important that is to really, again, telling that story of a touch point and where a person is if they participate in the Skills Development Fund program or some of these programs. It may have happened 5, 10 years ago. You have a good story to tell because they were probably making X amount at one point, and now they're at this other level. And a lot of that's a result of some of the training that's taken place. As all of us, at some point, we've been touched by someone or some training program or something in that regard that's added to where we are today. And so I think measuring this or taking this information that we have available allows us to tell a better story in our respective communities and across the street with the legislative bodies, and they in turn have an opportunity to share that within their respective districts and the like as well. And so employers benefit from that, and employees benefit from all of those. But thank you for the presentation. I'm glad that we're looking at measures in a more meaningful way. And again, is what I started with. It allows us to really tell a story. I think going in that direction is where we need to be headed. Thank you, Mr. Chairman.
So as I recall, this project started off, this is in response to the contracts that boards signed to take various monies from us. We owe a TANF, childcare, other monies. And we, I guess, recognized at the time, over my objections, I'm just kidding, that we didn't have time to do that for the next set of contracts. When would these, if we make changes, and I think we should, when would these go into effect for boards?
Some of these we may be able to do this year, and continue developing the rest of them by next year. But this year meaning this coming fall.
What month do we typically prepare and sign those contracts?
I don't know what month we normally sign.
A set of them are in June, executed in June, and another through the summer. So
The WIOA contracts are July 1st start dates, and then the adult ed is also a July 1st start date. And then typically the other contracts, the TANF, I believe, are October 1st start dates.
Okay. So I think we probably, I'm reluctant to do this, but I think we need to be pretty deliberate here and identify what it is we want to know. I think you made a tremendous case for there's 15 or 18 performance measures that really aren't performance measures. You have to do those things. You have to pass those things because all of the money is tied to those things. And so any class you took in college, pass, fail, I can make some assumptions about your performance in that class.
Well, my performance in my first 4 years of school was not outstanding.
Well, and there's a lot of reasons because you had to get through that.
Yeah.
And so measures that you have to get through, I think that there's generally a lack of enthusiasm for something that you simply have to check a box off for. That's okay. I don't get terribly excited about things that I just have to do, except you have to do them. And so, I think where we can build more meaningful performance measures, even around those things that we have to do, I think it better positions, particularly the boards, to be able to do some things that they want to do. And I think on your all three, your short, intermediate, and longer term performance measures, I think you build some things off of the requirements that if I were a local board functioning in a more local or regional area, I would say, this would really let me focus my efforts on some things that I really want to work on. I would pull one thread from your presentation. There are many to pull, but the one I would pull is this notion that no matter what you do with us, we need to know if that's successful or not. If our front desk person at a board said to you, "Have a nice day," somebody needs to check in before the end of the day to make sure that, in fact, they had a nice day. It is that simple. If we are really, truly going to engage in customer service, if we are going to be a customer service agency, and I challenge you to tell me how we're not going to be a customer service agency. If we're going to be a customer service agency, we need to measure to the absolute smallest measurement we can get. But we can't do that in a burdensome kind of way. The record keeping can't overwhelm the benefits to the people or the benefits to the program. And so I think you did a great job of sort of combining together some ideas with regard to, all right, these 18 items have to do. Can't even touch the money until we do these 18 items. These next, I lost count, 11 items, I think. These next 11 items, these are things that we really should be doing. These are things that it's within our power to do or not to do. And so we're going to measure these as well. A, because it lets us do our job better, and B, because it tells a really good story for us. Now, I think that our local workforce development boards, I think they do a good job with both client services and employer services. I separate those out. They're all clients, but let's separate them out. Yet, it would shock no one, I presume, to know that employers call me consistently to tell me that they can't get help from their local workforce development board. Now, that's for two reasons. One, they didn't get what they wanted. I get that. And two, they didn't get what they wanted. Those two different things. All right. Some things we just need to be more forthright about. We don't do that. And other things, if we do that, we should do that thing. And if one of the things that we do is help people get folks to work at their business, let's dedicate ourselves to that task. Courtney said a very important thing, which is it's a funnel, and we don't measure what goes into the funnel. We measure what comes out of the funnel. And you have to start measuring what goes in the funnel, because what if you're pouring the wrong thing in the funnel? We would really never even know that. And so, I think we've got an opportunity here to work with boards. I think there are appropriate times for a cram down. This is not that time. This is a time for us to work through these with boards and really understand even information that they might need to know. But more importantly, we need to come to an understanding about what it is we're trying to do here, and at what level are we interested in talking about serving people, okay? So whether it's job services through the workforce division, whether it's critical child care services so that there can be a workforce division, whatever it is, we need to be sure we're measuring at the level we need to be. I'm going to come back to this point repeatedly, so if you will just stipulate that I'm going to come back to this point repeatedly, I don't have to come back to it repeatedly, which is, but whatever we do, you cannot make the record keeping for the boards more egregious than the benefit of the information that they would provide. Always be on the lookout for that. Because if it takes more time to measure the thing than the benefit we get from the measure, we really still haven't measured anything, quite frankly. I don't think we're in danger of doing this here. I actually think everything you developed and presented today is completely doable. I think it's doable immediately. But I think we have a 12-month period between now and next June to really make these really work for boards and let them realize some things out of that as well. Later, I'm going to suggest a course of action that I think we should follow, and I think you'll understand what I'm saying there. The other thing that I divined from your presentation is that this agency has way too many silos still to this day. And part of your job as more senior staff here in the agency is we must tear down silos. So we came today to talk about sort of board performance measures that would go in their contract and measure how they get their money. But Commissioner Alvarez surfaced a very good point, which is there's other data we need too, and we would capture that simultaneously. And there are opportunities for boards to report data that would be more meaningful to TWC than the data we're collecting currently. And some of that data collection may require new approaches, new equipment, better attitudes, I don't know, whatever. There's a lot of things that might require. And we need to investigate those things. So we're not going to look, obviously, at board contracts in its own silo. And we're going to look in terms of data collection in general, how the agency uses data. And the other thing related to that, and this is a personal pet peeve of mine, and so this will be a consistent theme through these conversations, is this agency silos things into programs. We're really bad about that. And there's a reason partly for that, I understand. But we've got to get better organized around larger themes. So for example, you could easily put skills development fund and apprenticeship programs in the same theme, meaning there's a path to eliminate the middle skills gap that we have in the state. Those are two tools that we could use to eliminate the middle skills gap. There are many other tools that we have and will use for the same thing. But easily so, you could take the apprenticeship programs and put that in a discussion about career pathways, because that's a way to enhance your ability to move up in to career level 4. See, so these tools that are in our toolbox are going to get used a lot of different ways. So I think that our ability to kind of understand that this toolbox is multifunctional, and as are the tools, really starts us down that path to start eliminating some silos. Our data gathering capabilities are better than we think they are sometimes, but we have to stay focused on that. I know Adam's group is. I've had conversations with him about it. I'm confident that we can get this done, but we will run into problems, and so solutions will have to abound. Someone made the comment about Adam, Courtney. Somebody made the comment about sort of how far out do we start measuring? Well, day one is the first measurement. And then it occurred to me during the conversation that for the first meaningful quarter for someone who's in kindergarten and in childcare, their first meaningful measurement will be in quarter 244. And so it's an opportunity for us to understand how far we go. Now, in quarter 244 from today, I think I can predict with great certainty I'm probably not going to be a commissioner with this agency 244 quarters from now. I hope to be retired on an island somewhere by that time, but we'll see what happens. The point is, find some evergreen solutions that the next commission, the next set of commissioners, the person who takes over your position from you when you finally do retire to that island, make sure there are things that can lend to the continuity of TWC. I think you did that. Your presentation reflects that. I think there's some common goals here that are driving all this, and I think that's really good. I appreciate your view for the long term, understanding that we've got some short-term hurdles that we've got to do. Last comment on my part before we get functional here. Do not, under any circumstances, let the perfect be the enemy of the good on this project. Okay? Courtney, have I ever told you that failure is okay as long as you fail forward and fail fast? Yes, I think I have. I think I've told all of you that at some point. Because it's true. Failure is rarely embarrassing if you sort of put yourself out there and say, I'm going to try something here. And especially if you have a solution for the people who are impacted by that failure. We talk about failure as if it's a negative thing, but sometimes it's a positive thing because we learn how to do something better for somebody. At the end of the day, I just need to know that Texans can have confidence in their workforce commission, that this economy is going to continue to grow and present opportunities for them and their families, and that they can have the job and access to the jobs that they need for their community to continue to thrive. At the end of the day, that's what it's really all about. And I think our willingness to take risks and put ourselves out there to do that, I think we can do that. Paralysis of analysis is a killer because you get in that perfect mentality. We'll start with good. We'll get to great. We really will. We just got to start. And so we got some time to do that. I don't know if there's other comments from my fellow commissioners. I would just leave it with this. I don't feel like I have enough information today to say this is what needs to happen. What I would suggest is what I'd like to see, and we'll see what kind of agreement we have. What I'd like to see is for you to prepare exactly what it is you're going to do in terms of this is what we want to specifically add to the board contracts, what the timetable for that looks like. And then I would include with that, Commissioner Alvarez, with your permission, Commissioner Alvarez had some data gathering requirements that he wanted to add to this, sort of exclusive of the contracts with the boards. I'd like to see the timetable on that data gathering exercise and how that would look, because I think there's some benefit to that as well. So we'll bring that back around at the appropriate time to make that actionable, but that's where I think we are, and I'd certainly welcome any other comments or questions from my fellow commissioners.
Chairman, I have some closing remarks. To those that did the presentation today, Adam, Courtney, and Reagan, looking forward to continued discussions and improvements in measuring the performances, because this can only help customers make this great state even better, and of course, utilizing our tax dollars. One of the things that I will say, then I know this is something that Adam's mentioned a couple of times, and I'm the little Adam of our office, but with the data, and so it's supposed to be funny, Adam.
Well, we have good taste in cars, right?
And in ties. So one of the things that you referenced multiple times is how do you measure quality? I mean, how do you measure quality? And I can give you an example of something that I'm not sure how we measure it. Maybe you can correct me, but high demand. I'm going to use the example of the high demand grant that was awarded in South Texas for the CompTIA certifications. These individuals went through the course. Are we measuring those individuals after they graduate, or if they took the course, or if they received the credential? How do you measure and something like that? Personally, what I've heard from high demand grants that are awarded, TIP grants, skills development, not sure how we collect the data, but at the end of the day, what I do hear is that we as an agency and the local board put out a great product. And so I agree with the chairman and when he references silos. I actually heard that last night at dinner, how sometimes we as an agency have been doing this for years. Let me tell you, we have great boards. We have great people that work for this agency. We have folks that are in the audience that do great work for this agency. We should be promoting the great things that we're doing, and we should allow our boards the opportunities to think outside the box. We allowed them to do that during the pandemic. We allowed them to do that during Hurricane Harvey. Let's continue to allow them to do that. And I will quote from the chairman, no one fails. We are not going to go down on you, or are we going to ridicule you if you fail. No one is going to fail for bringing up an idea. And Courtney, we've worked on something with skills development for the city of FAR, or the outreach specialists where you allowed the boards to use TANF funding. We have 11 boards that are now actually applying to be outreach specialists, from the 7 that were our pilot program. So you got, what, 18 boards of the 28? Great work. Thank you for allowing the boards to be flexible. I will tell you something that I noticed that we didn't discuss, and I think there is a value in discussing it because I just recently heard from Jason Shaw, who some of you may have received this email. I know you did, and so did Kimberly and your team, Commissioner Demerson. And that is that we now have a deaf community chamber of commerce, the first in the country. A registered deaf chamber of commerce, not just in Texas, but in this country, we now have that, led by Jason Shaw. I didn't hear anything about VR services in the report. And I'm not sure if this was the appropriate time for us to hear it, but I did notice that we didn't talk leveraging VR with any outcomes.
So the original charge was to focus on board measures first, but I'll tell you, we absolutely went into this exercise with the idea that these measures could also be applied within VR, and we see VR services as one of those employability services that we were talking about because it does help a person obtain, retain employment, and maintain it, and it can be of value to the employers as well, obviously, to the degree that you can help that worker function successfully within the employer's work environment.
So from discussions we've had with folks in DOL, Chairman, I will tell you, Chairman referenced something earlier about shared services, but let's talk about blended services. We're the only ones that do that in the country, where we can get someone that works with apprenticeship and child care and adult education and literacy. What a huge marketing tool that is for us to be able to do that, where even the folks in Washington want to replicate what TWC is doing, and the fact that we're able to work together and share the ideas that we have. And again, I agree with Chairman. I think one of the things that I would recommend for those board members that are listening is that, we have great executive directors that represent the Workforce Solutions. I think we need to do a better job of blending, sharing our success stories with one another. We have great work that's been done. And whenever we all go somewhere and we discuss what TWC services there are, we always talk about the successes that the various boards have had. So I just wanted to say that. And again, thank you for the report that you all put here. Great report. And we hope that this was helpful, the recommendations that we made from the dais.
Yeah, to their defense, this was originally solely about board contracts for WIOA and TANF. We've gone far beyond the confines of that exercise at this point. I think it's a good thing. I think there's a lot of work for us to do. I'd love to nail down this board contract issue, particularly as it relates to WIOA and TANF and child care funds. We will definitely, I think there's unanimous interest in picking up the ideas on VR, adult education, and some other programs, and don't lose sight of. I don't want to put words in Commissioner Alvarez's mouth, but you heard 2 solid votes, and I bet a third for no more silos and blend those programs for the customers when it makes sense for the customer. Commissioner Demerson.
Yeah, just real quickly, I'll wrap up with good information, awesome opportunities for us. I know the team's worked hard. I'm looking forward to the information coming forward. It talks about customer service. I call it legendary customer service, and so we're heading in that direction. And also, Commissioner Alvarez, the blended, and Chairman, you spoke to it, the blended, we call it braided resource utilization, and they do that well with the boards, and this is just going to take us to even higher heights, I think, with these measures that we're talking about. So thank you guys for the presentation and the information.
All right, let's do this. We need to see some specific language for board contracts for the things you surfaced today. We need to see a timetable and a little better discussion. Commissioner, you asked for a discussion paper, but I assume that doesn't necessarily have to take the form of a traditional discussion paper. I'd like to see a little expanded version of data gathering, data ability, and anything surrounding sort of that ability for us to gather data. Commissioner Alvarez referenced a very specific data gathering exercise with terms of occupational codes and workforce placement. Anything you think of kind of surrounding those things. And then a third thing that we haven't really talked about is sort of how we would move this discussion to adult education, vocational rehabilitation, some other programs that we didn't touch on today. So we have a little bit of time on all of this, but let's don't take all the time that we've been allotted to this. Let's move this through and get this moving pretty quick. I don't see a reason to set a time frame here today. Everybody here is a professional. You'll do a good job and you'll get back to us soon. I know that. But unless I hear objection from either of my fellow commissioners, I think that's probably our best action plan to finish up this conversation today.
I agree.
No objection.
I'm okay with that.
All right.
Chairman, could I just maybe one point of clarification as far as your preference in terms of coming back to you as far as a conversation about this? Is it in a work session format or agenda item? If you have a preference one way or the other?
I don't have a preference.
Yeah, and I think the briefings that the staff
Okay.
provides are
We'll put
excellent.
together the information and determine
Thank
the
you,
best.
Randy.
All right. Hey, you know what? A lot of work went into that, you could tell.
Mm-hmm.
Really appreciate it. I think part of me wants to believe that you were already thinking about this before we started thinking about it, and that kind of makes me happy too. So thank you very much.
Thank you all.
All right, is there any other item come before the work session?
None here, Chairman.
None?
I think we probably should have a motion to adjourn the work session.
Chairman, I move that we adjourn the work session.
I second that
Been moved
motion.
and seconded to adjourn work session. Work session is adjourned.